Hello friends, in this video we are going to discuss about the mismatches in 2A and 3B for which department has issued a number of notices for the year 17-18 and 18-19. Now, during the process of audit, investigation and scrutiny, wherever the department has found that one has taken ITC more than what is appearing in 2A, they have tried to reverse the ITC by treating it as ineligible ITC. We have tried to justify to the department as to why the ITC is eligible to us and why 2A-3B mismatch was never a condition specified in law for the year 17-18 and 18-19. Now, understanding the difficulties faced by taxpayers and the department and the increasing number of litigation on this issue, the government has issued a circular of circular number 183 by 15 by 2022 dated 27th December by explaining as to how the differences between these two sources of data should be resolved. First of all, what is the applicability of this circular? Let's understand. This circular is only applicable for 17-18 and 18-19. According to me, this should be also understood to be applicable up to 8th October 2019. Why? Because rule number 36.4 was introduced from 9th October 19. What is rule 36.4? Rule 36.4 says that we can avail ITC up to a specified percentage of eligible ITC. So if 100 rupees is the eligible ITC, 36.4 said that up to 120 rupees I could avail my ITC as per 36.4 when it was introduced from 9th October 19. Gradually they reduced it to 110% to 105%. Now 100% matching of ITC is required. But no matching was required before 9th October. That's why this circular is not applicable after 9th October. It is only applicable for the period before 9th October 19. Also, it has been specified that whatever resolution has been provided through this circular is extremely case specific and only for bona fide errors. Whenever there is fraud, willful misstatement, or let's say there is a work where only billing is involved or any fraud is involved, in those cases department may not follow this circular. So they are trying to say that this circular is binding of the department only for case to case basis. It is not to be considered as complete interpretation of law. That is what has been said through this circular. So for instance, if anyone is engaged only in billing without actual supply, this kind of circular would not be applicable there. Also, it has been said this would be applicable only for ongoing proceedings and not for completed proceedings. So if I have accepted the contention of the department, I have already made the payment of taxes, I have not litigated that matter and those proceedings stand closed, that will not be revived through this circular. This circular is only applicable where I have litigated those matters. So it is always recommended to litigate these kind of issues, or where the litigation has not happened but may happen in future. So it is in dispute or will be in dispute in the future. Now, what are the scenarios which they are trying to cover through this circular which may cause 2A-3B mismatches? Let's understand that. Number one, where supplier has filed his 3B but not GSTR1. That means he has paid the taxes through 3B, but he has not filed his GSTR1 for that period. That will be covered here because he has already made the payment of taxes, but it is not appearing in 2A. So we are talking about those cases where 2A-3B mismatches are genuine, right? And ITC should be available, but it is not appearing in 2A. Second, supplier has filed 1 or 3B but has not reported the supply in GSTR1. So in other words, he has filed his 1 and 3B both, but he has forgotten to show the supply in 1, but he has shown it in 3B. So he has already paid the taxes. Third, he has shown the supply in B2C in GSTR1. He has not shown in B2B but shown in B2C. That's why it's not appearing in 2A. And he has already made the payment of taxes through 3B. Fourth, he has declared the wrong GSTN of the recipient. So that means it is appearing in GSTR 2A of some other recipient. So in such cases, it has been mentioned that the recipient in whose GSTN it is not appearing will also inform the relevant assessing officer in whose GSTN it is appearing by mistake, so that that particular assessing officer can take the steps against that particular recipient if he has availed the credit or not. So if it is appearing in, let's say, A's GSTN, it should appear in B's GSTN. So against A also the relevant assessing officer, his jurisdiction officer, can take steps, right? Having said this, a number of other cases have not been covered under this circular specifically, but to my mind would also stand covered. For instance, supplier has neither filed his 1 nor filed his 3B, but has already made the payment of taxes through DRC 03, or he has, or let's say when regard to credit note related differences, supplier has not issued credit note but has shown it in GSTR 2A by mistake, or he has wrongly uploaded credit note which he should not have uploaded in GSTR 1. That's why my credit note is resulting in my GSTR 2A getting reduced. Or there is a difference in value. That means my supplier has uploaded 100 rupees and he has given me invoice of 120 rupees. To my mind, even though these situations are not covered, it would also stand envisaged, even though it was not envisaged, but it would still be covered by this circular. Now, how will the difference be resolved in these kind of issues? So the officer, what he needs to do is, he first of all needs to see if all other conditions for taking ITC, for availment of ITC, has been satisfied. For instance, number 1, whether I have already got the tax invoice or the debit note in possession of me, or the tax paying document in possession of me as the recipient. Next, I have got the I have already received the goods or the services. So I have already received the goods or services. Whether payment has been made to the supplier. So next important thing is that the payment should have been made to the supplier. So if the payment is not made to the supplier within 180 days, we know the reversal of ITC is required. But here they are saying, even though it is not paid within 180 days, still eventually the amount should have been paid to the supplier. The consideration should have been paid to the supplier. If not, the reversal of ITC is required, which is proviso to section 16(2). Or the ITC is not required to be reversed under section 17 or 18, right? So under section 17 or 18, ITC is not required to be reversed. For instance, rule 42, 43 reversals, where my output is both taxable and exempt and I need to reverse proportionate ITC, or ITC is not blocked under 17(5). All those cases I would have to see. Also, ITC is availed within the time limit provided under section 16(4). So we know ITC can be availed up to September. For these 2 years, it was September of the next financial year. Mind you, even though for 17-18 the time limit was extended up to March 19, the condition was that it should appear in 2A. So if I have availed the ITC between October 18 to March 19, with regard to 17-18, I will not get the ITC if it is not appearing in 2A. So in any case, only and only if I have availed ITC in my return up to September 18 for 17-18, or my September 19 for 18-19, which is due date of these two returns, which is 20th October 18, 20th October 19, respectively, for 17-18 and 18-19. Only then the ITC would be considered to be allowable by the officer. Not only this, the most important condition, which is section 16(2)(c), that tax should have been paid to the government. Now there is no way for the departmental officer of the recipient to know whether the tax has been paid by the supplier to the government or not, unless and until there is a significant amount of digging involved. So here they have said that he can ask the recipient to contact the supplier for a certificate, and this certificate, if the difference is more than 5 lakh rupees, in that case certification by a CA or CMA would be required. So certificate would be given by the supplier's CA or CMA along with UDIT that the tax has actually been discharged by the supplier. Less than 5 lakh rupees, self-certification by the supplier is also sufficient that the tax has been discharged by him. If this certification is obtained, it would be deemed that that supplier has already made the payment of taxes and in such cases the ITC would be allowed. Mind you, once again, these are only for genuine cases, bona fide cases, and not for those cases where fraud is involved, or where those cases where one can say that one was only doing billing and there was no actual receipt of goods or services involved, right? So with this, we hope that you have liked our video. I hope this would help you in resolving a number of errors with regard to 17, 18, 18, 19 related 2A, 3B differences. Thank you so much for giving us a very patient hearing. Thank you.